So this was just put out moments ago, actually. And this is coming from all of them. Okay. Now, this is a proposal. It has not been signed by the judge just yet, but I'm sure it will be. It says stipulation regarding request for continuance of trial date and findings of excludable time periods pursuant to speedy trial. Now, I don't know why they have these listed separate. Oh, that's because that's right. They never changed that date. That's what that is. But it's Banks, Wilson, Grant, Jones, Lindsay, and Houston for the court trial date to start October the 14th of 20. Like I said, a proposal, even though it doesn't really say it up there, but that's what it is. Plaintiff, United States of America. That's the government. It's got all their attorneys listed and the close to this mic. It says Durk Banks, his attorneys, Grant, his attorneys, Wilson, his attorneys, Jones, Lindsay, and Houston. Keep up, Ratatouille. Make sure you do it correctly. Got a footnote number 1 here. After receiving a signed stipulation from all other defendants, the government was informed by counsel for the defendant Houston that the defendant Houston objects to the continuance of the trial date. So he's opposing it. But they're still respectfully submitting there is good cause to continue the trial. So the government's the one that's proposing this. Everybody's agreeing to it except for Houston. It says constitutes a reasonable period of delay for defendant Houston, who is joined for trial with stipulating defendants as to whom the time for the trial has not run and no motion for severance has been granted. Okay. Again, with that first superseding indictment, and this case was filed on November the 7th, 2024, where Banks first appeared before a judicial officer in the court in which the charges in this case were pending on November the 14th of 2024. The Speedy Trial Act originally required that the trial commence on or before January 23rd, 2025. Defendant Wilson first appeared November the 5th, and his required date was January 24th of next year. Grant and Houston then appeared on November 21st, 2024, and their dates were January 30th of 25. Jones and Lindsay was November the 22nd is when they appeared, and their date was January 31st. For those of y'all that's not familiar with it, a speedy trial, they have X amount of days to do whatever it is that they're supposed to be doing to get things rolling. Yes, Boogie opposes it, but I guess he's outnumbered. It says on November the 14th, Banks, they set the court date of January the 7th, trial date, should I say. On November the 15th, Wilson was set for a trial date of January the 7th as well. Then on November the 21st, Grant and Houston had a trial date of January the 14th. Now that makes it sound like they are being severed, but they're saying they're not. So I don't know. November 22nd, Jones and Lindsay set a trial date of January the 14th. All defendants are detained pending trial. The parties estimate that the trial in this matter will last approximately 14 days. Damn. That's a quick one. All defendants are joined for trial and a severance has not been granted. So please, Ratatouille, when you reread this, make sure you by this oh, I'm just changing the words. By this stipulation, the parties move to continue the trial date to October the 14th of 2025 and to set the following briefing schedule for all motions other than motions in limine and motions hearing date of August the 11th, 2025, motions to be filed by June the 30th, 2025, oppositions to such motions to be filed by July the 14th, 2025, and any reply briefs to be filed before July 28th, 2025. So those of y'all that actually do research and are if you're trying to keep up with the paperwork, whatever, just know if you don't have uh, anything else set for notifications on it, just know that in June and July, you're going to need to make sure you check for new documents. Says this is the first request for a continuance. Defendants request the continuance based on the following facts, which the parties believe demonstrate good cause to support the appropriate findings under the Speedy Trial Act. All defendants are charged with a violation of the United States Code 1958, conspiracy and use of interstate facilities to commit murder for hire resulting in death. That does not mean that they escaped on the interstate, Ratatouille. As well as use, carry, and discharge of firearms, machine gun, and possession of such firearms in furtherance of a crime of violence, resulting in the death. Then you have Jones, who gets the extra one from the machine gun. Okay. The government is in the process of producing discovery to the defense, which includes, among other things, approximately 230 gigabytes of digital evidence. Wow. That's almost as big as the Kanika Jenkins case. I think theirs was 289, 298 or 289. All the footage and all that, such as audio, video recordings, surveillance footage, and approximately 20,000 pages of reports concerning murder and other violent acts, photographs, witness statements, and medical report documents. There we go. Due to the nature of the prosecution and the number of defendants, including the charges in the indictment and the voluminous discovery that will be produced to defendants, this case is so unusual and so complex that it is unreasonable to expect adequate preparation for pretrial proceedings or for the trial itself within the Speedy Trial Act time limits. Well, yeah. Drill it, drill it, drill it. Defense counsel represent that they have various substantive obligations which necessitate the continuance of the trial to October the 14th. The list of obligations for the defense counsel is attached hereto as Appendix A and is incorporated as if fully set forth herein. In light of the foregoing, counsel for defendants also represented that additional time is necessary to confer with the defendants, conduct and complete an independent investigation of the case, conduct and complete additional legal research, including for potential pretrial motions, review the discovery and potential evidence in the case, and prepare for trial in the event that the pretrial resolution does not occur. Defense counsel represent that failure to grant the continuance would deny them reasonable time necessary for effective preparation, taking into account the exercise of due diligence. E. Defendants believe that failure to grant the continuance will deny them continuality of counsel and adequate representation. In other words, their attorneys might quit on their ass. F. The government does not object to the continuance. G. The requested continuance is not based on congestion of the court's calendar, lack of diligent preparation on the part of the attorney for the government or the defense, or failure on the part of the attorney for the government to obtain available witnesses. 7. For the purpose of computing the date under the speedy trial by which defendants Banks and Wilson's trial must commence, the parties agreed that the time period of January the 7th to October the 14th are inclusive should be excluded pursuant to the Title 18, all them alphabets and numbers, okay? Because the delay result from a continuance granted by the court at the defendant's request without government objection on the basis of the court's finding that the ends of justice served by the continuance outweigh the best interest of the public and the defendant in a speedy trial. Failure to grant the continuance would be likely to make continuation of the proceeding impossible or result in a miscarriage of justice. The case is so unusual and so complex due to the nature of the prosecution and the number of defendants that it's unreasonable to expect preparation for pretrial proceedings or for the trial itself within the same time limits established by the speedy trial. Failure to grant the continuance would unreasonably deny defendants continuity of counsel and would deny defense counsel the reasonable time necessary for effective preparation, taking into account the exercise of due diligence. The purpose of computing the date under the speedy trial by the defendant's trial must commence. The parties agree that for Banks and Wilson, the time period of January the 7th to October the 14th, inclusive, and for the defendants Grant Jones, Lindsey Houston, from January the 14th to October the 4th, inclusive, should be excluded pursuant to that law right there. Because the delay results from a continuance granted by the court at defendant's request, so this is the defendant's request, without the government's objection, on the basis of the court's finding. And it repeats everything I said up there. 9. Nothing in this stipulation shall preclude a finding that other provisions of a speedy trial dictate that additional time periods be excluded from the period within which trial must commence. Moreover, the same provisions and or other provisions of Speedy Trial Act may in the future authorize the exclusion of additional time periods from the period within which trial must commence. It is so stipulated. And like I said, the judge has not signed it yet. It was just presented to the judge this moment. This one says, I am Dirk Banks' attorney. I have carefully discussed every part of the stipulation and the continuance of the trial date with my client. I have fully informed my client of a speedy trial rights. To my knowledge, my client understands those rights and agrees to waive them. I believe that my client's decision to give up the right to be brought to trial earlier than October 14th is an informed and voluntary one. I have read this stipulation and have carefully discussed it with my attorney. I understand my speedy trial rights. I voluntarily agree to the continuance of the trial date and give up my right to be brought to a trial earlier than October 14th. Now, he signed that on Christmas Eve. See that? But they're just now presenting it to the judge. Then we have Grant's attorney, and it looks like it says the same thing. And Grant signed it on Christmas Eve as well. Day-Day's thing, they did theirs on December the 20th. Huh. I wonder if that's why he's changing his mind now. That's crazy. Keith Jones, he did his on the 20th as well. Or it looks like that says 27th. But this says the 20th. Yes, those things do make a difference, just so y'all know. Lindsay, his was first. Okay. Counsel for I'm not sure what this is. Let me okay. I guess Christy O'Connor, this is her conflict of interest, or not conflict of interest, but her calendar. She has a trial date in July, but it's only estimated at 30 days. Marissa Goldberg in Florida, February. Another one in March. So Dirk has 3 attorneys. This one, and this one. Grant, counsel for Grant. They don't have a name, but okay. Do they? Name up there either.